Welcome to our latest program. My name is Vivian Schiller. I am with Aspen Digital, a program of the Aspen Institute. So glad that you could all join us today. Just last week, the Reuters Institute for the Study of Journalism issued their annual report. It is a global survey, highly recommend it for all kinds of useful information. But they once again, as they do every year, have monitored across many countries where people get their news. Unsurprisingly, the number of people or the percentage of the population that get news and information from social media continues to grow. It varies from country to country, from a low of about 40% to more than 80% of the population in some nations. But what we know is more and more social media is a place where many of us find out what's going on in the world. This is a very good thing. Access to information has never been easier. So many ways to find out what's going on. And yet, those of you who have joined this session will be well aware about the flip side to that. There is disinformation, there is misinformation, there is hate speech, there is election interference, there is cyberbullying, terrorism, extremism, polarization. Many of the world's ills, sadly, are reflected on what we experience on the platforms. Around the world, there's really has not been an agreement on what to do, and even on who should be the ones deciding what to do about the state of affairs on platforms. The Delta is particularly acute when it comes to what many in the US think and what European regulators think, academics and other experts. That is until now. Last week, and get ready for a very long name, the Transatlantic High-Level Working Group on Content Moderation Online and Freedom of Expression issued a report more than 2 years in the making. The commission included 28 political leaders, lawyers, academics, representatives of civil society organizations, tech companies, journalists, and think tanks from both sides of the Atlantic. And they have taken on the not easy task of coming up with a set of recommendations to tackle a lot of the issues that we face today: hate speech, violent extremism, and disinformation online, all while protecting freedom of speech and a vibrant global internet. We are very lucky today to be joined by 4 members of the commission who will meet very soon. They include Harlem Jeff, who comes to us from Vienna. You'll meet him shortly. He's a representative on freedom of the media for the Organization for Security and Cooperation in Europe. He has held many, many high-level positions as a champion for press freedom. Eileen Donahoe is executive director of the Global Digital Policy Incubator at Stanford. She has served as U.S. ambassador to the United Nations Human Rights Council in Geneva during the Obama administration and has held, again, many other roles. Jeff Jarvis is professor and director of the Tao Knight Center for Entrepreneurial Journalism at the Craig Newmark Graduate School of Journalism at the City University of New York. He's the author of many books and many blogs and has a long history in journalism, both as a working journalist and now as a professor and often a critic. And finally, Susan Ness is a distinguished fellow at the Annenberg Public Policy Center and a former member of the US Federal Communications Commission. She is also the co-chair of this commission. So we are going to begin with Susan, who will start us off with a very high-level overview. While we're bringing Susan on, just a few housekeeping announcements. The format for this program is Susan will present. I will then ask the panelists some questions. We'll have a moderated conversation, and then we will take questions from you. Anytime, starting right now, you can click on that Q&A function link on the bottom of your screen and add your question. Please, we ask you to include your name and affiliation if you feel comfortable. Also, where you're coming to us from, is it provides helpful context. So, Susan, thank you very much. And I'm now gonna thank you for being here with us. And I'm now gonna turn it over to you to give us a little bit of grounding on the report.
Thank you, Vivian. And we thank the Aspen Institute for hosting this session. We're delighted to talk about our final report, Freedom and Accountability, a transatlantic framework for moderating speech online. The Transatlantic High-Level Working Group is a project of the Annenberg Public Policy Center of the University of Pennsylvania in partnership with the Institute for Information Law at the University of Amsterdam, the Annenberg Foundation Trust at Sunnylands, and the Embassy of the Kingdom of the Netherlands in Washington, D.C. Our working group is truly transatlantic. Half of our members are from Europe, and the other half are from North America. They are legislators, government officials, tech execs, civil society leaders, and academics. But they represent a wide spectrum of viewpoints. All have a deep respect for freedom of speech, which is essential in a democracy to hold governments accountable. Our motivation to form the working group was the flurry of legislation in Europe during the past 4 years to address the proliferation of hate speech, terrorist propaganda, and disinformation online. Some of these laws ignore due process and shield free expression. Conversations about regulating platforms had also begun in the United States, but there was little communication across the Atlantic on the best way for democracies to protect their citizens online without harming democracy itself. Our mission was to find a practical path forward to address hate speech, violent extremism, and disinformation without chilling free expression or further fracturing the internet. If democracies cannot define a coherent set of fundamental principles and government frameworks, the field will be defined by political powers that have very different goals. We knew that by working in tandem across the Atlantic, we'd tap the best ideas while avoiding conflicting rules. We strived to promote scalable solutions that were well-grounded in law, technology, and business. And we wanted ultimately to restore trust among government, tech companies, and the public. Bad actors are increasingly more sophisticated in their online methods to tear down democratic institutions. Trust is essential for governments, platforms, and the public to work together to tackle the future challenges ahead. In the course of our work, our members published 14 briefing papers. All of these are available online, and they did deep dives on specific laws or topics like artificial intelligence or intermediary liability safe harbors. So here is a summary of our recommendations. Our big daddy: regulate on the basis of transparency, not content. Transparency has different purposes. It enables governments to develop evidence-based policies for platform oversight. It pushes companies to examine problems they would otherwise not address, and it empowers people to better control their information environment. Platforms have latitude to create their own terms of service and community standards, and that's a good thing. It promotes competition. But they must clearly tell the user and the regulator what their policies are and how they're enforced, such as when the platform chooses to delete, decelerate, or demonetize user content, or when the platform does not remove problematic speech that has been flagged. With transparency, there must be accountability. The flexible rules creating the transparency framework should empower a regulator or other authority to audit and enforce transparency. The oversight authority could be a government agency, could be an independent auditor, or an industry board like FINRA, which regulates stockbrokers in the United States. That authority would set baseline transparency standards, audit compliance, require swift redress for users that are adversely affected by their decisions, and sanction repeated failures. The authority would also have insight into the algorithms that social media platforms use to make recommendation and prioritization decisions. That means deciding what content users see in their feeds. The auditor would not have access to the platform's secret sauce, that is, the underlying source code. The rules would also set different levels of disclosure for the public, for researchers, and for regulators. Vetted researchers would analyze the data that's provided, and that in turn would inform the development of evidence-based regulation. Another one of our recommendations was to provide efficient and effective redress mechanisms. We discussed concepts for two complementary systems of accountability: social media councils and e-courts. These ideas are worthy of further study. Social media councils are independent, multi-stakeholder bodies created to make consequential policy recommendations. They could provide a forum for public to be heard, or they could be formed to decide appeals from moderation decisions. The second concept is a national system of e-courts. These are online courts with specially trained magistrates to swiftly resolve cases involving human rights or determinations of legality. There would be similar to small claims courts, for example, in the United States, but online. Our final major recommendation: use the ABC framework to combat disinformation. Going after bad actors and their deceptive behavior, rather than trying to take down each piece of harmful content, is more effective and has less chilling effect on freedom of expression. Disinformation often is legal speech that's been manipulated and spread with the purpose of sowing discord or distrust. Government regulation of disinformation is hard to do without harming freedom of expression. Disinformation campaigns could be coordinated across different platforms. They may be promoted by foreign or domestic actors, or a combination of both. And the virality, the reach in combination with speech, makes them especially problematic. We saw the COVID-19 pandemic has created an infodemic of harmful material initially spread online. Our report is just the beginning of the conversation. It offers a path forward, a flexible framework to address online harms while making democracy more resilient.
Let me unmute. Hi, thank you, Susan. That was having read the report. That, of course, is an extremely high-level overview. I encourage everybody to read the details of the report if you haven't already. So many questions, so many things to talk about and interrogate, and about where we go from here. But the first question I want to ask you is, what has been the response? You're talking about some of the biggest platforms in the world, Facebook, Google, including Facebook's WhatsApp and Instagram and Twitter and what have you. What has been their response to these recommendations?
Well, first of all, we had tech companies who were part of our group, both large and small, both American and European. Oftentimes, we just look at the big three or four tech companies, but the world is much more diverse than that. Certainly. And then, so they were part of the development of the recommendations. We had a series of roundtable discussions both before we wrote the report and afterwards with specific tech companies to determine what would work, what would not work, how it would be implemented, what needed further study, and the like. And now this really is just a beginning. There's lots of research that needs to be done, and it needs to be done in combination with tech companies, so that we actually get results that work for the public and for democracy.
So you see the path forward then is to engage more directly on these recommendations, or continue to engage
Absolutely.
directly. Yeah.
Absolutely. It cannot be done by just government, by just multi-stakeholders. It's got to be a combination. And for that reason, we underscored the importance of restoring trust in that process so that we can work together to find the solutions.
Well, let's drill a little deeper on that. And I want to bring in Eileen and direct this next question to you. Is it the responsibility, whose responsibility is it to manage what content is experienced on the platforms? Is it solely the responsibility of the private sector to protect free expression and democracy when it comes to all of the, when it comes to toxic or harmful content?
So the simple answer is it's primarily the responsibility of the private sector, but we would recommend government oversight, as Susan just said, with respect to transparency of rules, and then ability to audit the outcomes of algorithmic promotion and demotion, et cetera, and also to provide redress mechanisms. Those are the first steps we would recommend from government. But let me go to the more complex way to understand it. So this was a transatlantic commission. So we were speaking, across the Atlantic divide, and we thought we should turn to international human rights law as the basis. International human rights law says it's the obligation of governments to protect the free expression of citizens, and the responsibility of the private sector to respect free expression and remedy it. So that was our starting place normatively. The problem is that governments are confused about whether they want the private sector to take down more content, even if not illegal, and whether that violates free expression. And private sector companies are confused about whether they are required to adhere to the same limited standards that governments would be required to apply, such as in the United States, the First Amendment, and that they are prohibited, they should be prohibited from taking down more content. So there is basically conceptual confusion about what are the rules that apply to the private sector. Another aspect, there are two other aspects I would like to mention. One is that there's actually a tension here between protecting free expression and protecting the quality of discourse and democracy, the integrity of democratic processes. And I would say that the private sector has more leeway as with their own free expression to think about the impact of the discourse on their platforms than would governments. For certainly the United States, under the First Amendment, there are very limited ways in which government would be allowed to restrict speech. I think the private sector has more leeway to exercise their own speech. And they do in many regards. You know, if you look at the powers that private sector companies already exercise over the speech on their platforms, they set the rules, they interpret the rules, they sometimes put labels on speech, and they also have the power to promote and demote with algorithmic tools. And so those are ways in which they are shaping discourse that are kind of under the surface and that are beyond what a government should legitimately do under, let's say, the First Amendment. So I would encourage platforms to do more to protect democracy in the name of their own free expression.
Well, you raise a very good, important point about how complicated this is. There are perpetual trade-offs and how much confusion there is, frankly, you know, in the United States around what the First Amendment protects. As we see Twitter and in particular becoming more aggressive in takedown, sometimes a little bit, sometimes Facebook less so. the cries of this being a violation of the First Amendment just shows how much confusion there is about what the First Amendment protects, and so on. Harlem, I'm going to turn the next question over to you. How do we preserve, just sticking on this issue of preserving free expression while combating hate speech and illegal content and disinformation? We've seen instances around the world where autocrats have taken down or have gone after, frankly, in many cases, either individuals or gone after news organizations in the name of protecting the population from disinformation, and in the name of keeping the public safe, but often with really just a thin veneer of taking down content that they don't like. So how do we preserve free expression throughout the world?
Thank you, Viviane. Good morning and good afternoon for those who are in Europe, like me. I hope this report will be a landmark in this discussion, because first, it proposes an approach, not all the answers, but which has to do with this, how to avoid censorship and undue restriction of freedom of speech while combating violent extremism, terrorism, but also hate speech in general, and all harmful or unlawful content, which is not exactly the same thing, or manipulation of information, viral deception. And at the same time, how do we preserve another international human rights principle, which is the freedom of expression, which is the basis of all democratic society. I think, and I will follow up on what Aileen and Susan says, one of the interests of the report is that it was based on a discussion, on an intercontinental discussion. So it's based on the fact that on the one side, we have a world dimension, which is the one of most of the social media and the tech company. The users are from different jurisdictions, but on the other side, the states are in charge of ensuring that legislation is enforced. And the state also have to respect international laws. And that's one of the aspects of your question. And I think that this report is important because it tried, I would underline especially 4 dimensions and 4 keywords: transparency, remedy, behavior rather than monitoring the content, and international, intercontinental approach. And so I think that it's through this combination that we can encourage both the states and the tech company, but also civil society, the academic, to engage in an approach to solve the main contradiction, which has been underlined, which is that on the one side, we have the state who asks the company to ensure that unlawful content will not be disseminated, that the manipulation of information will not have the possibility to spread on social media. But on the other side, also everybody says the tech company should not be the arbitrary of free speech. And the reality is that under many demands by the state, but also by society, by citizens, the tech company has been more and more putting in place online content moderation, deleting content, blocking content, and so on. And nobody exactly knows how it works because of the use of artificial intelligence, of algorithm, and so on. And so that's why, more than trying in this report to say, this is what should be the terms of services, this is what should be deleted. We say terms of services, the process should be transparent. There should be a review in permanence of what is done. There should be remedy system so that both the state, through its regulator, for example, or the users or civil society can ask how to correct a decision of deleting or of allowing a content to be disseminated. We should concentrate more on behavior when it's about disinformation. the fact that people could, for example, use bots or troll factories rather than the content itself. And we should always try to build an international approach of this online content moderation.
Thank you, Harlem. Jeff, I want to turn it over to you. Harlem reinforces the notion from the report, as Susan led with, about transparency in particular, and how the focus really of the recommendations is specifically around transparency. What does that look like exactly?
Thanks, Vivian, and thank you and Aspen for doing this. I'm glad that we're getting this discussion going. Transparency is the way toward accountability. That's the belief of the group. Too much regulation to date, I believe, has not been evidence-based. It's been based on presumptions and fears. And so we need transparency, we need data to be able to inform our decisions going forward, I think, in two ways. First is around impact. We need a hypothesis. Example, the belief that we're in filter bubbles. Rasmus Kleist-Nielsen at the Oxford Institute, or the Reuters Institute at Oxford, regularly debunks that idea. Another idea is that young people are the problem, and thus we need media literacy, where Josh Tucker's research at NYU has found that the kids are all right, it's old people like me who are causing the problems online. So what is the hypothesis? What do we need to know to investigate that hypothesis? What kind of interventions might come out of that that we need to test? That's the kind of transparency and cooperation and collaboration we need with platforms and regulators and civil society and the academe in a flexible framework. The second area of transparency that Susan touched on is about accountability. If a platform makes a compact with the public and says, this is the standard we will uphold, then the idea here is that they can, as Susan said, each platform and each community can have their own standards, as they should. That's part of their freedom of expression. That's part of their freedom to assemble. But they should be held to account for what they promise. And so then the question becomes, what kind of data is needed for researchers and then in turn government to be able to say that, yes, a platform has made their promises good or has not. The primary piece of work that's needed now after this report is around this question of what transparency is needed. I'm going to plug Aspen for a second, and I know that you're working on work on content moderation. And so it's my personal hope that a lot of the discussion that can occur now is, what do we need to know? Why do we need to know it? And what good can come out of knowing that, so that we can have, rather than a one-size-fits-all laws like Netzdege in Germany or the just rejected hate speech law in France, that we can have a more flexible discussion as new things come up, like COVID and medical disinformation. We have a dialogue and data and evidence backing that up to decide what actions we should or should not take.
Yeah, that all makes sense. It feels sometimes, for those of us who follow a lot of the decision-making, or and sometimes the decision-making on behalf of the platforms is to do nothing and say nothing, that there seems to be a lot of lurching back and forth around what to do. And I think a lot of what we see sometimes, let's take, for example, Twitter's decision a few weeks ago to, in one case, append a fact check to one of President Trump's tweets, in another case to put a warning on it, that they then set a standard that they cannot keep for the rest of their users. So what are the unintended consequences of what we see in a lot of the actions that the platforms are taking now?
It's a great question, and one that doesn't have an answer right now. And I think we're only going to know
That's why I
by
asked
working
it, because I
forward.
figured you'd come up with one.
And I think that part of the problem in this discussion is there's an effort right now to start a boycott of advertising on Facebook. Well, to do what? What is your goal? And the problem is, too often the expectations of those outside the platforms are not met with specificity, including in law. If you look at the UK and its harms report and the idea of taking down legal but harmful speech, well, that's a chill on speech for sure. And if the law is not specific in what is harmful, then we're not going to know, and the platforms are going to err on the side of taking down too much. The efforts to affect Section 230 mean that platforms would then be cautious, and we would have less dialogue online. So I think the greatest unintended consequence here is a chill on society finally relearning after Gutenberg how to have a conversation with itself.
Yeah. I want to, I've got just a couple of more questions I want to ask the members of the commission. Just a reminder, and I see many of you are putting questions in, which is fantastic. We're going to get to them shortly. Again, please, if you feel comfortable doing so, please include your name, your affiliation, and where in the world you are, because it's always interesting to see where somebody's coming from. We'll get to your questions very soon. But in the meantime, I want to just drill down on two more points that Susan included in the summary, and there's a little more detail in the report, and that is the remedies around. You suggest two possible ways to hold platforms accountable. One is what did you call it? A council, and another are a form of a kind of court of appeals. So I want to just talk about those a little bit more. Eileen, maybe you can talk a little bit about the Social Media Council, what you all have in mind there. It certainly, to many of us, sounds similar to maybe what Facebook has announced with their Facebook Oversight Board.
Yes, it is. Absolutely. The Facebook External Oversight Board is an example of a social media council. And the basic idea here is that platforms set their own rules, and then they have the power to interpret those rules and apply them to user speech. The social media councils provide a vehicle for those users who've had their speech taken down to appeal those decisions. And then seek redress and remedy for bad decisions. And this is different from the other proposal in the report, which is e-courts, which we came to understand as another very important mechanism, because in many of the laws that have been popping up around the world, particularly, let's just take NetzDG as an example, governments have defined categories of speech as illegal, but then they are shifting the judicial function and responsibility onto the private sector to assess liability and to assess illegality. And so we recognized, it was actually Judge Spano who really came up with this idea, judge on the International European Court of Human Rights, basically said, no, that's the responsibility of government. That's a rule of law issue. If a government defines something as illegal, it's a government responsibility to own the decision about it. That should not rest with platforms, as many governments are doing. On the other hand, we need remedies for private sector companies making decisions according to their own rules that may be incorrect. Let me give you, and I just have to give you one interesting example that's recent, is Mark Zuckerberg's decision recently to, he personally decided that the Trump post on when the looting starts, the shooting starts, did not violate Facebook's rules. That caused an uproar because that's an incredible power of interpretation that he took with a group. And this is what the External Oversight Board would oversee. I also have to mention the Twitter case you brought up is real. It's very important to say Twitter did not censor that speech. Twitter exercised its power of speech to put labels on those tweets. And oh, by the way, it was because they applied an exception for public figures to say things that would otherwise violate their rules. So there's a lot of complexity here, but we should not be saying that Twitter violated the speech of President Trump by putting a label on it, and that Facebook did the right thing by interpreting its rule in the way that they did, when the average person, and I bet their own External Oversight Board, would determine that it violated Facebook's rules.
Well, this is what I was saying, something as simple that's been around for so long and fundamental as free speech is, again, misinterpreted. To your point, Twitter, Facebook, the platforms, they are protected by the First Amendment. They are not responsible for, they are not a government that that can be in violation of free speech. Obviously, the devil's in the details, and it gets very complex because people perceive, and they are so powerful, perceive that they have the ability to squash speech. So this is where it gets very confusing.
Is it possible? I just want to say one insight we got at our first ditch meeting was there was almost a triangle of interest on free expression. You've got to think about who's free speech. Users are most important, and that's why platform liability for user speech is a bad thing. That undermines free expression. There's also the free speech of the platforms. That shows up in their terms of service, their community guidelines, their algorithms. Then you've got the free speech interests of society, and that's where protecting democracy come in. And we have to think about that tripart sense of free expression interests together.
Yeah, I'm going to start weaving in some questions from the participants of our program today. Still sticking with this notion of the Social Media Council. This question is, and Susan, I'm going to bring this to you. This is from Stephen Balcom from the Family Online Safety Institute. In reference to, of course, we recognize some similarities to the Facebook Oversight Board. His question is that the model for what you are proposing? Sorry, I'm paraphrasing you, Stephen. Or have they missed some of your key recommendations in the way that they've set it up?
It is not the model. We are very clear in our report that while we expect and hope that Facebook will take advantage of the group that they set up to improve their decision making, we envisioned a very independent type of social media council, which would have a number of companies, not just one company, where the members of that board would be appointed by outside parties that were not decision makers within a company. And with respect to Facebook, while they deployed outside search firms and the like, ultimately the decision who was going to be co-chairing, who was going to be on the board, was a matter that went up to the high levels of Facebook itself. So that is not the model that we were envisioning, but we are looking forward to having research be done after it's been in operation for a period of time to learn lessons, what works, what doesn't work, and what impact it has actually had.
Just a follow-up to that, Susan, and this related to what you're talking about. This comes from Thomas Kadri, assistant professor at the University of Georgia School of Law. He asked if the rules, procedures, and enforcement mechanisms become centralized, i.e., he references the fact that Facebook has suggested maybe other platforms join the Oversight Board, or perhaps emerges with the Oversight Board that you're proposing, or regardless, that if those rules, procedures, and enforcement mechanisms become centralized and homogeneous through industry-wide oversight, does this pose dangers for pluralism and freedom of expression?
One of the things that we emphasize, and that I emphasized in my opening remarks, is that it's vitally important. It is good for platforms to come up with their own terms of service and community standards. I see that diversity as underpinning democracy as well. Our rules that or the framework that we're proposing is intentionally flexible so that you don't have a one-size-fits-all regulatory regime that would not comport with the vibrancy and independence online. We are also very mindful of what is going on around the world, where more and more countries are taking control of the online discourse, and we're very worried about that. So we are not looking to model that system at all.
Speaking of the rest of the world, and I'm going to shift gears again. By the way, there's a lot of questions around Section 230, which I'll come back to later, but that's a very US specific issues. But Harlem, I want to address this question to you. It comes from Robert Borstein, Albright Stonebridge Group here in Washington, D.C., where I'm coming from. He asked, did the panel consult with any individuals or groups outside of the transatlantic region, particularly in places like India, Brazil, South Africa, and Indonesia? If not, why not?
Well, to my knowledge, I don't know about these specific countries, but of course, on my side and on our European side, I would say we have been looking also at the way this discussion is developing in Europe, not only the EU, even if EU has, of course, strong legislation and is developing legislation on the digital sphere, but we have a lot of European countries who are in the Council of Europe, which means that they have to abide to the decision of the European Court of Human Rights. And in the OSCE region, we even have several countries, for example, of Central Asia, which are not in the Council of Europe, but which have very strong OSCE commitments on freedom of expression and freedom of the media, and who anyway have to abide to the UN different relevant convention and international treaty, like the International Covenant on the Political and Civil civil rights. So it's for us very important to have an approach which can be of interest worldwide, I would say. I just want to underline the fact that in the report, that's also why we don't propose one magical formula, which will be, for example, the Social Media Council. We propose a combination, and Social Media Council are part of it, so that with transparency, with the possibility also for academic research to have access to the process, to look at the way artificial intelligence are used for content online moderation, but also with the role of regulator, like the FCC in the US, or Ofcom in UK, or the CSA in France. There is different actors which can look at the way the content moderation is put in place. And there is also the role of the judiciary. And this is, I would just mention this example because there was a reference made by Jeff to the recent decision by the Constitutional Court in France about the hate speech law to censor, to delete a part of this law. And one of the bases of the decision of the Constitutional Court is the risk of over-regulation, of over-blocking of content without due process and without judicial oversight. And that's also something we have been looking at in the report, and that's the reason why we have introduced this proposal of e-courts. That's the idea to have specialized courts which could work online, which could be able to perhaps look more quickly than usual court, but on the base of the case law and the jurisprudence, for example, of the Supreme Court in the US, or of the European Court of Human Rights in Europe, which could look at the way the online content moderation is implemented by the platforms through their terms of services are compatible with international human rights and especially the protection of freedom of expression. And because the terms of services, of course, is a decision by each platform, but for a very big platform, it is more and more recognized that they become de facto public space. And that it means that they cannot just delete content without taking into account the fact that it has an impact on the freedom of expression rights of their users. So that's why in the report we try to establish a kind of combination and mechanism which respect the fact that the platform can decide of their terms of services, they can put in place their own oversight mechanism, but they also have to take into consideration the wider public interest in the respect for the existing legislation and jurisprudence regarding the protection of freedom of expression.
Okay. Thank you, Harlem. Jeff, we have a number of questions that specifically get at, and this comes back to transparency and accountability. a number of questions about the importance of making sure that data from the platforms is made available to the research community as part of that transparency. So there's two related questions. The first comes from Zeev Sanderson, hopefully I have not mangled your name, Executive Director, NYU Center for Social Media and Politics, who asks, says the report and panelists underscore the importance of data access for the research community, which is essential towards evidence-based policy rather than policy based on folk wisdom and media hysteria. However, there is a tension, I'm paraphrasing the question, between a push for more robust data access on the one hand and the fear articulated by many folks in the privacy community around protecting consumer data. Are there any frameworks or systems to increase researcher data access while alleviating those privacy concerns? Before you answer, a related question from Catherine Grant in Washington, D.C., who also wants to know about the potential for collaborative research with the tech industries. What issues within the space are most needed, and how should tech companies best enable credible research on these issues? So you get the gist.
Yeah. The terrible paradox of the Cambridge Analytica case was that it was Cambridge, and data was handed over or allowed to go out to what would have seemed to have been a reputable university. And of course, it wasn't. It was misused, and it violated the rules, and the rules have changed, all that being true. But that's made the platforms extremely skittish about allowing any data out. We've seen the problem with Social Science 1 to try to get privacy dealt with and GDPR dealt with. It's very difficult. So the idea here, as Susan said, is that there are tiers of release. There's what do researchers need to know to be able to answer the questions once those questions are agreed upon? And can there be assurances of safety within that world that researchers can be trusted? Again, Cambridge Analytica couldn't be, so nothing's going to be foolproof. Then there's a question of what government knows in turn, and what government needs to know, and worrying about privacy there as well. And then there's the question of what the public should want to know about impact, about what happens on the platforms. These are extremely difficult questions. But I think that the present system is no system at all. It's researchers asking, demanding data so we can know better what the impact of social media is. And then it's the social media platforms saying, but we have GDPR and we can't release anything. So I think government is going to have to intervene here. Frankly, in any of the meetings, if I try to bring up the phrase safe harbor, I would get batted down. So I'm not suggesting a safe harbor, but I do think government is going to be required to set standards for data release so that companies can do it with some level of safety, and so they can be held accountable for doing so.
Right. Otherwise, they're grading their own homework.
Yes.
Plus, we need access to the brilliant researchers and academics around the world to solve these complex issues.
Which leads to the second question you had. I don't want to forget that. Is yes, I hope that there's an opportunity for collaborative research across research institutions and the platforms. A lot of what we have now, the platforms, of course, do their own research. They know what's going on there. What we don't know is take citizen Y. What does this person see across all the platforms? What is that person's actions across multiple platforms? That's going to be very important to try to get collaboration to do.
Yeah. Eileen, this next question is for you. This is from Megan Guy of King River Capital, who asks, today many platforms rely on users to be the front line in identifying and reporting hate and harassment, disinformation, and toxic content. What responsibility does the panel, I'm asking you, believe that platforms have in ensuring user safety and preventing users from ever seeing hateful content and abuse rather than taking it down after the fact?
What responsibility? Well, first off, there's another side to that problem, which is over-reliance on automated filtering, which has the problem of taking down more content that should not be taken down. So everybody who's concerned about this needs to understand there's another side to that picture, especially if you care about free expression. Obviously, the platforms bear that responsibility, but the systems aren't perfect because of the scale that we're dealing with. We don't have ability to precisely get it exactly right in assessing what counts as hate speech in terms of service or community guidelines, and taking it all down. And, you know, the Christchurch case is sort of the extreme version of the consequences of instantaneous upload and spread around the world, even though everybody in that case might have agreed it should be taken down. So there isn't a silver bullet, but I would say imposing liability on platforms for user-generated speech that gets put up will have consequences for free expression that are gigantic, and will undermine the concept of free society and freedom online. And so that is not the solution. That is the one thing governments have tended to do, to push platforms in the direction of taking down more. I don't have a solution to the questioner's problem, but this is what everybody has to be working on, this combination of automation, human moderation, and platforms, yes, taking it more seriously that they bear responsibility for what's up there, but there isn't really a silver bullet.
And Pamela Peresky, another one of our viewers, has a similar question, but I think you may have answered it, which is, to paraphrase, you know, short of speech that constitute true threats, legal harassment, defamation, and incitement to imminent illegal action, what set of standards is capable of being communicated transparently in a way which users have the same understanding of what is permitted? I think that's exactly the difficulty that you're alluding to.
Well, this goes back to your first question to me, which is the difference between the First Amendment in the United States and Article 19 of the International Covenant of Civil Political Rights, which was the standard we chose to use because this was a transatlantic group, and we think of platforms as generally global, and having an internationally recognized standard is more helpful. I will say that whereas the First Amendment limits the speech that can be taken down by governments, and that in some cases platforms think they too must adhere to, is in imminent incitement to violence. That is not the case under international law. There is much more leeway under Article 19. If you go look at the text, there are other bases through which a platform can be consistent with free expression under international law and take down more than would be allowed in the United States. It doesn't mean there's one right answer. And that's the problem. That's the reality of a plural society. And it has never been the case. There is diversity of interpretation of that standard. It doesn't mean the standard's unimportant. It's a basic commitment to free expression. And you have to have, it does prevent many forms of repression. It doesn't give you the final answer of every precise instance of when speech should be taken down or not. But I do think this is where transparency and rules and articulation of how interpretation is done, that's why it becomes so important that platforms are articulating the rationale behind their decisions.
Thank you. Susan, as our resident former FCC commissioner, I bring you a question from Jonathan Levy of the FCC, who asks, what is the role of competition or the limitations thereof in determining requirements for the platforms?
The role of competition is very important, and a lot of the decisions or the recommendations that we're hearing about will hamper, not encourage competition. The more requirements that are placed on platforms to take down information, the more sophisticated the requirements are for monitoring or for using artificial intelligence, the less capable smaller platforms are to be able to comply with these requirements. Similarly, in Germany, even taking down within 24-hour period of time, very difficult to do, to be able to monitor across the world. We found that oftentimes the major platforms are able to comply and have fairly sophisticated systems with human monitoring of the decisions by artificial intelligence. But even there, that's an extraordinarily expensive system. And what oftentimes happens then, the folks who are putting up the hate speech and violence and disinformation simply go to the smaller platforms that are not able to respond. So competition is a big piece of it. We did not, as a group, undertake a review of competition policy or antitrust, nor did we look at privacy, which is another vehicle, frankly, for helping to address some of the issues that we've been talking about. Those were outside of our purview.
Thank you. Jeff, there's a pair of questions here that get at a topic I know that's near and dear to your heart, which is media literacy. So the question is, what role, this comes from Mark Newton, who's a journalism teacher. What role does media literacy education play in all of this? For example, should demonstrated media literacy proficiency be required to graduate high school and be admitted to college and military? Chauncey, coming to us from California, also has a somewhat related question, which is, now that we have a better sense of the ever-evolving, interconnected social media ecosystem, what kind of action can inform individual users of social media to bring these insights to our local policymakers? So I group those because they're somewhat related.
Well, you come to me as a heretic on this topic.
I know, that's why I called on you.
So as I'm a fellow journalism instructor, but I fear that emphasizing media literacy puts the focus on us in media. I'd rather make people in media more public literate. I'd rather make this more about listening to the public, and keep that in mind. The power that we're trying to preserve here is that finally we can hear publics who were not heard in media. That is the essence of Black Lives Matter and Living While Black and Me Too. These are struggles that have been there for a very long time that were not covered in mainstream media. And so I think that the primary challenge, to my mind, and this is me speaking, not as a member of the commission, is that we've got to make the media better at listening to the public. Now, having said that, of course, I think that the fundamental answer to all the problems we see now, the epistemological war we're undergoing, is education. At one definition or another, that's the problem that we're trying to tackle here. And I'm reading about the early history right now of cheap books, when steam power presses came to the books. And there was a struggle of those who wanted to educate the public and those who wanted to entertain the public. And that's a struggle that goes on forever. So I don't think that we can mandate a level of education and literacy in this area any more than we already do in any others, and that's fine. I don't think it's going to solve the problem. I think the problem is a lack of trust in institutions. So one of the members of the group said that the essence of what we're trying to accomplish here, this person is a regulator himself, is to increase trust. That there's a lack of trust in the platforms, a lack of trust in government and government's actions around the platforms, and that leads to the belief that transparency will be the best weapon to try to rebuild trust, so we have a better idea of what's going on, what's the impact, how are decisions made, and so on.
Thank you. We are quickly running out of time. So unfortunately, I don't think we're going to get into the questions about what we do about Section 230, which I think would need to be the topic of about 18 other webinars.
Though if I may note, in a Rate My Skype Room moment, I see that on Susan's bookshelf right in front is Jeff Kosseff's The 26 Words That Created the Internet. So let us all recommend that everyone read that book and be up on 230.
Okay, and follow Jeff Kosseff, who's got a very amusing Twitter feed. And there's also questions about the role of the UN. So apologies to those of you. I think those are important questions. But with 3 minutes left, I'm just going to ask each of the panelists to say incredibly briefly, what is the most important next step to take now that this report is out that you feel is critical to take in order to bring these recommendations to action?
I guess
Susan,
I'll go first.
go ahead.
Conversation. Basically engaging with folks, decision makers, policymakers on both sides of the Atlantic to have these conversations, examining further what we mean by transparency, what accountability would be operable, and having those conversations over a period of time, not in keeping with an election calendar, but rather in keeping with developing the understanding so that these can be adopted ideally on both sides of the Atlantic. So that would be our next step, certainly, is looking at what research is needed, pinpointing that so that we can continue the conversation.
Great. Harlem, and everybody please briefly, we have 2 minutes left. Harlem, go ahead.
Yes, we will of course use this report in the OSCE region, and we will try to ensure that OSCE participating states with the tech company can use it as a base to advance the conversation on the regulation of online content and of the platform. And as it's about the next step, I will also mention that on the 8th of July, my office in the OSCE will organize a webinar, which is accessible to all, and perhaps is on the chat now, on the use of artificial intelligence specifically and its impact on content moderation, but also on other issues like surveillance, and which have, of course, direct impact on freedom of expression and freedom of the media.
Okay. Jeff?
Research on impact, not only of the platforms, but especially now that we have experience with the regulation to date, what has the impact on freedom of expression been with government regulation?
Thank you. And Eileen, take us home.
So I would say, I would emphasize the responsibility of democratically oriented governments to get their acts together. They should pick their heads up and see the global picture. We have digital authoritarianism growing around the world, and the concept of internet freedom turned on its head. They should not be participating in the erosion of commitment to free expression by imposing liability on platforms for user speech. And on 230, don't revoke. Simple answer. And I will also say, private sector platforms, embrace your own power of free expression to do what's right on your own platforms.
Thank you. Those are some great final messages. Eileen, Jeff, Harlem, Susan, everybody who joined us, thank you so much. This video is going to be posted in its entirety. You can look for it on the Aspen Digital Twitter feed a little bit later today. Thank you so much. I'm sorry we couldn't get to all of your questions, but there'll be much more on this to come. Thank you so much, and bye-bye.